Okay, let's stay on schedule. I know a lot are still yet to return from lunch, but we're going to keep plugging away. The next we have is evidence, which I know everyone can use, a little education on evidence for the family law attorney, and it deals with winning. So keeping with what we said, we have Lisa Karges from our Tampa, Florida office. Lisa is one of our, like Heather Biaggi, our more decorated attorneys at Cordell Cordell, one of the top performers in 2013, I think rookie in 2011. Rookie of the Year. We give awards annually to our top performers. So please welcome Lisa Karges.
Well, good afternoon to all 30 of you that showed up for the second half of today. 31. Great. I'm really excited to be here to talk to you about my topic, evidence, and how you develop a winning strategy for that evidence. Now, we could go through and we could talk about all the rules, and I could tell you about hearsay and all the objections, but you can look that stuff up, and frankly, that would be really boring. So what I'm going to do instead is I'm going to talk to you about how you effectively present your evidence, how you organize yourself for trial effectively, how far in advance do you need to prepare, what evidence is relevant to your case, and what is the best way to showcase that evidence. So I want to give you some pointers on how to be ready to get the best possible result for your client. So my first tip is know your judge. You can't effectively present your case if you don't know your audience. We're all human, we all have biases, we come from different backgrounds, and knowing this information in advance can really put you one step ahead of the other side. So what type of info do you want to know? Well, do they have kids? Are they married? Are they separated? Are they divorced? What type of neighborhood do they live in? What memberships do they have? What hobbies do they have? What can you do? Well, you can Google the judge. That's actually a really effective tool. You'll find out a lot of information about them just through Google. You join local groups. It's really important that you become members of your local bar associations. Inns of Court is also another great organization that you should check out. I suggest you go to the happy hours, you go to the dinners, you go to the lunches, you talk to your judges. I had a case about 6 months ago, and the other side was trying to argue that private school was the only way to go. And I'm from Florida, and in Florida we have a horrible public school system. So it was a good argument. But the way he presented it to the court was, well, Judge, the public school system here, as everyone knows, is deplorable. And the teachers are uneducated, and they don't care about the children. And in fact, putting these children in public school rises to the level of child abuse. The judge's wife had been a public school teacher for 30 years. So the point of my story is, you want to know a little bit about your judge, because it wasn't a bad argument to make, it just wasn't the right argument for this particular audience. So you want to talk to the judges, you want to be personal with them. I think this is invaluable information to have, and it's going to put you one step ahead of the other side. I really enjoy when I walk into court and the judge goes, "Oh, Ms. Karges, so nice to see you again. Do you mind staying for 5 minutes after so we can chat about that relocation issue from last week?" The other look on the other side's face is really priceless. And we walk out of court and the other side's going to their attorney, how come she's best friends with the judge? So I think that gives you a definite advantage. So what else can you do? Well, you can ask them. A lot of judges have preferences and they're really willing to share them with you. For exhibits, for the presentation of your evidence. We have a judge in our jurisdiction who is really technology crazy. She was the first one to implement Skype. I had all these witnesses appearing via Skype. I didn't even need to use it, but I was going to use it because she wanted to use it. We also have a judge who hates email, and he's really old-fashioned. In fact, that might be him on the slide up there. When I'm in front of him, I'm not going to use videos. I'm not going to do anything. I'm not going to even ask for a telephonic appearance. I'm not going to do anything that's out of the norm, because that's not what he likes to see. So it's not going to be effective with him. So you don't want to use, you want to just gauge what you're doing towards the type of audience that you have. So when do you start your trial preparation? Well, in my opinion, it's the very first time that you meet with your client. Think about what you do when you initially meet with your client that first time. You talk to them about the facts of their case. You're determining what the potential issues are. This is basically going to be the summary of your litigation. You want to get as much information as possible early on so that you can determine what type of proof that you're going to need and what type of evidence you're going to be able to use. I recommend that you start an outline right from the beginning, assuming that you're litigating every single issue in the case. And as you move through the case, you can delete and take away the issues that resolve or settle, and you can add issues that come up. You can start collecting your documents for proof, and when you have a witness that could potentially help you with that issue, you're going to jot down their name. And you're doing this because the closer you get to trial, it's going to put you in a much better position. So let's say you have an issue on support or alimony, and the other party doesn't work. Well, why don't they work? Are you going to need a vocational expert? Do you need a medical expert? Do you just need W-2s and pay information? You want to start thinking about these things really early on. And if you jot your thoughts down now, it's going to help you move the case forward better. I have a lot of experts that I work with in different areas, and one of the things that I like to do is kind of match up the personality of my client or the other party with the expert. For example, we have a mediator in our jurisdiction, swears like a sailor. I don't use her with my more conservative clients, but she's really effective for some of my younger clients. So discovery is ongoing, mediation was unsuccessful, and now you've set your case for trial. So what do you need to do? Well, deadlines and calendaring those deadlines are critical to your trial preparation. As soon as I schedule a trial, I'm going to calendar a 90, a 60, and a 30-day meeting with both my paralegal and then also a separate meeting with my client. And the purpose of these meetings is going to discuss where we're headed and what we need to do to get ready. With your client, you're going to be discussing the major issues. What are they? Have they changed since your initial meeting? With your paralegal, you want to discuss the evidence and how you work towards obtaining what you need. These deadlines have nothing to do with your court deadlines or your external deadlines, but what they can do is those guidelines can guide you for what you need to be discussing during your 90, 60, and 30-day meetings. All right, so 90 days away from trial. What are we doing? Well, you're reviewing your exhibit file. If you've planned from the beginning, you already have one started with the key pieces of information that you need. If you don't, then you need to start putting it together. You want to review any exhibits that you had from temporary hearings. Are these going to still work for you? Do you need new information? Do you need updated information? You're going to meet with your paralegal. Are your exhibits legible? Do you have the right number of copies? Are any pages missing? We all have those clients, they turn their bank statements and credit cards, they leave off the last page because there's really no information on the last page. You can get objected to in court and not get your exhibit in because you're missing that page. So it's really important that you check these things out. Another thing I see is they don't, whatever page 2 of 7, that they had that charge on that they don't want the other party to see, you're suddenly missing that page, you need to go back and get it. If for nothing else, to know what's on it, so you're prepared if that comes up. You want to start thinking about the order that you want to use your exhibits in, because this is going to help you with how you order your witnesses. You want to make sure your witnesses are available, and you also want to start talking to them to get a feel for how they're going to testify. At least your friendly witnesses. So, why are we doing all this at 90 days? Well, you need time to make changes for your witnesses. You need time to get a continuance and obtain a hearing on that continuance. And you need time to schedule and take your depositions. So at this point, you should talk to your witnesses and find out what they're going to say, get a good feel for how they're going to testify. I I like to give my clients a one-page sheet that has their space for them to fill in the name, the address, the occupation or title of the person that they want to testify, and then a few blank lines to give me a summary of what they're going to say. I can't tell you how many times a client has said to me, you need to call Miss Jones because Miss Jones is going to say this. Well, I call them up and Miss Jones says, I hate your client, I want them dead, and I'm testifying for the other side. So you need to know this information now. One, because you don't want to put them on your witness list and have the other side become aware of them. And two, you don't want to figure this out in the middle of your trial that your witness is going to bomb you. I'm sure you've all seen it. The testimony that can happen at trial itself, where the other side has clearly not even talked to the person that they're putting on the witness stand. And you're like looking at it and you're like, oh God, shut up, don't keep going. And then you're like, wait, keep going because you're actually helping me with this. So you want to make sure you talk to these people in advance. I also want to have depositions scheduled for anyone that I know that the other side is going to use. You want to get this done as early as possible. I like to set them up all for the same day, 30 minutes apart, so I can just go right down the list and find out what they're going to say. Get your subpoenas ready. Don't assume that your witnesses are going to show up. I made this mistake in the very beginning and it ends up screwing up your timing and it screws up your strategy. So just assume you're going to depose them and that you're going to subpoena them. A tip for the other side's witnesses, try giving them a call. Don't even bother scheduling a deposition, just call them up, say, I'm so-and-so, I'm part of this case, I think you might be a potential witness, can you tell me what you have to say? People will tell you they'll talk to you, just without a subpoena. A lot of times the other side won't even let them know that they are a potential witness, so they won't even know why you're calling, and they'll give you all sorts of great information. So what else are we doing in 90 days? Well, you want to make sure your discovery requests are all updated and sent out. It's going to take 30 days to get all that stuff back in, and at that point you might find that you need additional stuff. You may need time for motions to compel, extensions of time, that sort of thing. So you want to make sure that you give yourself enough time to get those documents in before trial. You're also continuing to review and update your exhibits and your exhibit and witness lists. Every time I'm in my client's file doing something, and I come across an exhibit that I think I'm going to use later, I pull it out, I make a copy of it, stick it back in the original folder so I still have it, and then I take my copy and I put it in a separate folder. When I'm getting ready for trial and I'm really starting to pull my final exhibits together, I pull that folder out and I'm halfway done because as I went through the case, I pulled out what I needed. Other things we're doing at 90 days. We're doing lots of things at 90 days so that the closer you get to trial, you don't have a lot to do. You're going to confirm that your paralegal is scheduling all your appropriate depositions. You're going to check your pleadings. Do you need to amend your pleadings to request additional relief? This is really important. You do your pleadings at the beginning of a case, and it may take months, or in some cases even years, to actually get to trial. So you really want to go back and double check and make sure you don't find yourself in a malpractice position. In Florida, for example, our alimony laws change all the time, and they had a major change, I'd say about 3 years ago, and the change was adding a whole new type of alimony. They called it durational alimony. And before that, we had alimony was great if you were only been married for 2 years or 5 years, and you just wanted to sort of bridge the gap alimony. Or you had to be married over 17 years, and then you could get permanent alimony. Well, that left everyone between 2 years and 17 years at a big disadvantage. So they added this form of alimony called durational alimony. Well, still today, attorneys haven't gone back and amended their pleadings to include this type of alimony. I will still get documents come across my desk that don't mention it. They mention the other forms, but not durational. Well, we also have case law in Florida that says that you need to specifically plead what type of alimony you want. On 2 separate occasions, with 2 separate judges and 2 separate opposing counsels, they mentioned durational alimony in their opening statement. I'm like, excuse me, judge, they didn't plead for durational alimony. And I rarely interrupt opening statements, but for something like that, I'm going to. and the judge kicked out the claim right in their opening statement. So they were all prepared to present their alimony case, and they didn't have anything to present. So you don't want to find yourself in that position at trial if you can avoid it. Notice of intent to use summaries, and you want to make requests to see the other side's summaries at 90 days. I know an attorney that does this around the time of mediation, which is kind of ridiculous. That seems a little bit too early. You're not even set for trial, but you want to make sure that you have time to see all the backup documentation, to counter their summaries, and they. So, in my opinion, it is better to file your request, even if you don't know if you're going to have a summary or if you're working on it and it's not finished yet. I still go ahead and file that now. If you do end up using it, you don't have to worry about doing this later on. Make your request for judicial notice if you haven't done so already. They're usually statutory and state specific, but if you do it in advance, and 90 days is plenty of time in advance, then you won't have to worry about it later on. Do you need any memos of law? If so, start them now. Memos of law, especially good ones, take a long time. You need to do a lot of legal research, and you want to keep working on them. They kind of evolve. You need to change your facts, you need to change your argument, so you want to start working on them now. And in my opinion, your memos of law don't have to be a new or novel issue. Sometimes I think even the basics are good. We have a judge in our jurisdiction that specifically asks for them. He says he doesn't know the law. So he wants memos of law for all trials. And I had a trial about 2 months ago where I sent in 2 memos of law, and one was on alimony, and that was a basic one. It was just basic alimony law. And the other one was on a mortgage issue, premarital home, pay down the mortgage component. That one was a little bit more complex than normal. But the judge walks in on the day of trial, and I sent these, I prepared them months in advance, but I sent them to the judge about 2 to 3 days prior to trial. Well, he read them. He walks into the courtroom, sits down, and he says, well, counselors, I've read her memos of law, and I agree with her. So I'm going to give you 5 minutes to settle this case before we continue with trial. Well, needless to say, the case settled relatively shortly thereafter. So memos of law can really be used to your advantage, and I don't see attorneys use them an awful lot. You want to review your evidence code, and you want to review the statutes. It sounds kind of tedious, and it really is, but for every trial that I have, I go back and I read the statutes that address the issues I'm litigating. And the reason I'm doing it is because statutes are long and they're boring, and they have a lot of information in them. But when you're reading them with a purpose, when you're reading them for the specific issues of your case, you're going to find things in there that may be helpful to you that maybe you glazed over the last 10 times you read the statute. You want to do the same thing with the evidence code. Review all your predicates. Make sure you can get your evidence in, and you can meet all the predicate criteria. Also, around 90 days, you want to meet with your tech person if you have one. We're moving into an era where technology is becoming more and more prevalent, and I'm finding it even more so in the courtroom. It's an expensive tool sometimes, but it can be really effective for your presentation. I think the best thing to probably happen in divorce law is Facebook. You don't want to just print out those black and white pages. You want, to project mom up there drinking her face off, because that's going to help you. You want to have a big color poster board of all the comments about dad liking the cocaine jokes. You wouldn't believe what people will put on there, so you really should download those pages and use them to your advantage. In order to do that, though, you need to have a basis in technology. You're not going to be able to do that kind of stuff 30 days, a few weeks before trial. You need to do it early. So you want to know what your options are way in advance. Block your calendar 3 to 4 full days prior to trial. The week of trial is crazy, and your clients are often going to go, I forgot to tell you this, or I need to meet with you right now to discuss this. So you need to be available for them. If you're sitting down to gather your exhibits, to talk to your witnesses, to prepare your questions, at the last minute, these 3 to 4 days, or even a week prior, you're not going to be prepared. You're just way too late. And it can be done. I see attorneys do it all the time. I mean, I've done it before. But early preparation is what sets the good attorneys apart from the mediocre attorneys. If you've never gone and watched somebody do a trial, I recommend that you do it. You can usually call up, a judge in your jurisdiction and say, hey, do you have anything going on this week that I can come sit in on? Go watch one with attorneys that you've never met before. You can really tell which attorneys are there prepared and which attorneys have no idea what they're doing. Themes. I like to have a theme for trial, and I think themes are really important for your evidence. It's going to tie your case together, and the point is to have a common denominator for all your evidence that kind of supports your side, and it's going to ring out through your presentation. An example would be in like an alimony case, maybe entitlement, if you have to pay your spouse. Recently, I used a theme of real life experience matters, and the case that I had with that was about, it was a custody issue, and when you do a social investigation or a custody investigation, you have the home visits, which my client did great at, and the interviews with the investigator, which my client was awesome at. But then you have the psychological testing and all those other tests that they do. My client failed those miserably. So I kind of made my theme, real life experience matters. Kind of like when you're in high school and you take a standardized test, you could be valedictorian of your class, but you're just not good at test taking. So that was kind of the idea that I wanted to use. And I had said it like 50 billion times throughout the course of the day. Real life experience matters, Judge. So I get to my closing argument, and of course I say, bottom line, Judge, real life experience matters. The judge interrupts me and is like, really? Real life experience matters? How many times are you gonna say it? Okay, well, maybe I overdid it. But the interesting thing is, those words ended up in the final divorce decree. She used them verbatim. So I think a theme is really important for trials. All right, finally, we are at 60 days. You've done a lot of the heavy lifting already, and that's put you in a really good position. So what are you doing at 60 days? Well, you want to check and make sure you don't need any additional depositions. Were any last-minute witnesses disclosed by the other side? Someone you missed or need to go back to? Double-check all of your own witnesses and make sure they're ready and that those subpoenas actually went out, and if they haven't gone out, get them out. Make sure they have no last-minute concerns. Sometimes when I talk to witnesses at the beginning of a case, they tell me something different 30, 60 days later, so you want to double-check with them, make sure they're going to say the same thing. You want to start preparing your outlines for trial testimony. I've seen attorneys out there that will write down every single question they're going to ask, and then I've seen attorneys that make really detailed outlines, and then the attorneys that show up without an outline at all. And it seems to go with the attorneys that have been practicing longer, don't think they need as much stuff written down. I can tell you that I still write down every single question that I ask every single witness. I've done about 30 family law trials in the last 5 years that have lasted over 1 day. I've done about 10 that have gone 2 days or longer, and I still write everything out. It's going to help you in case you lose your place. Trial's extremely fluid. Things change. Things happen you don't expect. So if you have at least a safety net, that's going to help you. And it's also going to help you with your very own client, which I'm going to discuss in a little bit. But if you're newer to extensive litigation, I really recommend that you have a detailed outline. You want to start preparing your trial notebook. I'm going to talk about trial notebooks a little later too, but you should have a good outline going for what your trial notebook's going to contain. This will make more sense when I talk about it. Are you going to have stipulations for trial? Well, you better get with the other side now. You only got 60 days left. You want to be working on a summary of what those stipulations are going to be. Usually when I have stipulations, they're going to be basic facts about the case. The dates of birth of the children, the date of the marriage, something like that. It's good to have this information easily accessible for the judge. I like to have a one-page sheet that goes right in the front of my exhibit notebook. It's It's got a larger font than anything else I'm using, so it's just the basic facts for what opposing counsel and I have stipulated to. And I find that that works really well. You want to confer with opposing counsel when you're going to do your exhibit exchange and how you're going to do it. I like to get this kind of stuff in writing. I've had it before where we agree to exchange by a certain date and I don't get their stuff till 10 days later, and I've said, hey judge, we had an agreement to do this and they didn't abide by it, and the judge will throw out their stuff. Well, it's not very helpful to go to trial when you don't have an entire exhibit notebook that you can use. So get this in writing, get it done in advance. You also want to gather all your expert information. The CVs, the resumes, that kind of stuff. Having a great report is not going to do you any good if you can't get that report into evidence because you didn't lay the proper foundation. And things like this are basic pieces of info that you should have in advance. So you want to make sure that 60 days out, you're getting this type of information. All right, so let's talk for a little bit about depositions. You want to make sure that you have all the transcripts ordered in advance. It's going to cost your client less money the earlier you order the transcript, so you want to make sure that you order them early. It'll also give you time to summarize them, to highlight them, to tab them for trial. I really recommend that you do that. In my outlines for direct and cross, I like to reference the transcript, especially problem areas where the testimony got tricky or the other side might have been lying or they didn't really know how to answer the question. I want to make sure I have the line and the page number referenced in my outline so I can quickly refer back to it. Your deposition should be published during trial. I often see a lot of attorneys that will file with the court 300-page depositions. If you think the judge is reading that, they're not, okay? I've had judges even say to me, don't bother filing that, I'm not gonna read it, okay? They want you to read it to them during trial. And you can add so much more emphasis if you do things this way. So I recommend you don't file a deposition and you stick with publishing. Okay, so now we're 30 days out. You should prepare a proposed final judgment using the findings of fact per issue as a guideline in the presentation of your evidence. Now, I have some judges that don't want final judgments at all. I have other judges that want them before trial even starts. They want your proposed final judgment before you even start the day. And then I have other judges who want their proposed final judgment within, 7 days of actually having trial. Well, I don't know about you, but if you've ever done a 2 or 3 day trial, the last thing you want to do after that's over is look at that client's file anymore, because you're pretty much done at that point. So if you do them in advance, you'll be one step up. You'll only have to tweak it for any testimony that actually happened that maybe you hadn't considered. It's also really going to prepare you for presenting your case to the judge, because what do you do when you prepare a final judgment? Well, you're going to prepare all your findings of fact. So what does it take to do that? Well, you have to know what the findings of fact are going to be. So it's really going to help you create your outlines. You also want to start working on any pretrial motions and stipulations and memos of law. You want to finalize them, get them finished, because you started them 60 days ago. So now you really want to polish them and get them ready to go out. If you're doing this at 30 days, it's going to leave you plenty of time to focus on the other details. Finally, you want to determine if you need a continuance, and if so, you want to get that motion filed and that hearing set ASAP. All right. You want to start assembling your trial notebooks and exhibit notebooks in their final format. And I'm going to talk about both of these notebooks a little bit later on. And you've already started doing this. Like I said from the very first slide, you started putting this information together right from your initial meeting with the client. So if you've really started doing that, you'll have a good jump on what's to come. 7 days prior to trial, we're now in the home stretch. You're in great shape because everything's pretty much done. So all you're doing now is fine-tuning your presentation. You want to finalize any outlines and your trial testimony. Again, you should be tweaking things, not preparing them. Review all exhibits from opposing counsel and prepare your cross exams. 7 days out, you should have at least exchanged your exhibits with opposing counsel by now. You want to meet with your client, you want to go through those exhibits. Maybe there's something in there that you don't even know what it is and you need to ask your client about it. Or maybe not, but your client needs to know what exhibits are going to come up during trial so they can be familiar with them, so they can be more comfortable with them. It's going to cause them a lot less anxiety if you show them what's coming in advance, and they're going to make a better witness for you. I also like to prepare all my objections to their exhibits in advance, so I kind of have an idea of where I want to go. And I want to really lay out why I'm objecting, so I have that all done in advance and I'm not trying to do it on the fly at trial. You want to finalize your arrangements for getting boxes and computer equipment to the courthouse. Sounds kind of, really need to do that in advance. Yeah, you do. Sometimes I'm hauling 30 files into a courtroom. I can't do that by myself, and if it's raining or there's other conditions that are going to prevent it, you want to make sure you've thought about these things in advance. You want to make sure all that tech stuff that you've now used is set up and ready to go. I like to go into the courtroom in advance if I can. Sometimes the judges will let you do that, and they'll let you practice or set up or make sure your audio-visual equipment actually can work with what you're trying to do. So if you can do that in advance, you should. Most important thing, determine where lunch is going to be. You want to make sure that you have that thought about in advance. I had a trial once where opposing counsel came back 10 minutes late from lunch. The judge had already started without him. You don't want to find yourself in that position. So if you thought about it in advance, where you're going to go, what you're going to do, you won't have to worry about being late. You want to make sure that the paralegal on the case is available during lunch, if at all possible. For any last minute or unexpected issues, you can give them a call. I actually take my paralegal to court with me, and I use her to, I usually give her an outline of the factors for the issues I'm trying. So for like custody cases, I give her an outline of the children's best interest factors, and she goes through and she takes notes on the testimony that's being offered, because that's not something that I'm really equipped to do at trial. I'm the one presenting the case. So she does that for me, and then I can use that to put into my proposed final judgment. You want to arrange in advance to have someone in your office be available for quick legal research. I try and have another attorney that I've discussed the case with, at least a little bit, so they have a little bit of a background. Any points that I think may be problematic that might come up, so that if I need something, they're ready and available to help me out. Typically, I'll just say, Judge, can I have a 5-minute break? And I'll go out, make a call by lunch. I have all the case law that I need. The judge won't mind coming back to that kind of stuff. You simply can't be ready for every potential issue that's out there or every potential argument that can be made, but you can be prepared to deal with it at trial. Okay, so trial notebooks. I said I would get to these, so here they are. They should be organized and easy to reference. And when I say a trial notebook, what I use is a 3-ring binder that has how I'm going to present my case. I consider it my trial Bible, basically. And if I've prepared properly, and if I put this notebook together properly, the only things I'm using during trial is this notebook and my exhibits. That's it. Although I'm hightailing all that stuff with me, I'm not actually going to use it. In my opinion, there's a 3-second rule in family law cases. If you can't find what you're looking for in 3 seconds, you've lost the judge's attention, you've lost your focus, you're thrown off your game, and no one's paying attention anymore. And 3 seconds can go by very quickly. So you want to make sure you have everything at the ready. So when I prepared this book, you should develop a system that's really right for you. Let me show you some of the sections that I like to put in mine. Now this isn't all of them. Typically what I'm going to do is my first page is going to be all of my opening notes or my opening statement. You want to think of the notebook as working your way through the day of trial. So I start with my opening. The next sections are going to be my witnesses. My client's going to be first because my client's always first. I'm going to have their outline for what I'm going to ask them. I'm going to have the deposition transcript if the deposition was taken. I'm going to have any exhibits that I need that witness to get into evidence for me. And I'm going to have all my notes on that witness for what they're going to say. And I'm going to make a tab section for each witness. I usually put in a section of case law, and by this I mean typical case law that I'm going to use in every single case, those standard landmark cases that you have. I usually like to have a couple copies in there, so if some issue comes up that the judge needs it, it's there. I also put any memorandums that I've done in there that are special to this case and their supporting case law. Have a section for my closing, of course, and I also put some blank pages in for the closing, because as trial goes on, I make notes on what I want to say in my closing, so I like to have some blank pages there at the end. Although, like I said, I'm bringing the entire file to court with me, you really should be able to get through trial with just this one book. That's the idea. And then you're also going to have your exhibit notebook, and your exhibit notebook is just that. All it has in it is your exhibits. I'm going to have my index in the very front, and it's going to lay out all the exhibits that I'm going to use in the order I'm going to use them in. And I have an example at the end too to show you, so you'll get to see that. But I make 5 copies of this notebook. One goes to the judge and sits with the judge throughout trial. One's with me, one's with my paralegal who I brought with me, one's with opposing counsel, and then I have one for the witness stand. And I see a lot of attorneys that don't prepare extra exhibits for the witness stand. I don't know why. You don't want to be asking, can I approach the bench 50 billion times during the day? It's a waste of time. And there's a lot of shuffling back and forth. And remember my 3-second rule. You've lost your attention in 3 seconds. So you want to make sure that you have something up there that's separate. You want to list everything in the order of admittance, if you can do so. This is going to keep everything easy for the judge and easy for you as you move through your case. You're also going to seem a lot more prepared if you're doing things in order rather than skipping back and forth. And this can be challenging, and this can require some planning. If you haven't prepared your case and you haven't laid out exactly how you're going to do things, then you won't know that order in advance. In Florida, we have a financial statement. It's called the financial affidavit. Everybody always sticks this with the bank statements and the credit card statements and all that nonsense. Well, really what we use it for in Florida is for income. So it shouldn't be with those exhibits. It should be in a totally different section, because my income questions aren't going to be where my credit card statement questions are and my debt and asset questions are. So you have to think about that in advance. In my own exhibit notebook, I will put in opposing parties' exhibits as well, just so I have one notebook to work off of. I will make an index for their exhibits, and as you'll see, my index has a column for admitted and identified. So as I move through the case, I can just check the box if I've gotten it admitted, if they've gotten it admitted, if it was renumbered along the way. And then finally, at the end of the notebook, for myself only, I like to have a general list of evidentiary objections. This is just simply going to help me remember some of the objections that maybe I don't use very often. And I like to look at that list when opposing counsel is doing their questioning. It's going to really keep me focused to make all the objections possible. And remember, if your case goes into appeal, you're going to have won and made those objections. So the more you can make, the more valid ones you can make, the better off you'll be. All right, witness selection. I want to talk to you a little bit about witnesses. Bottom line is you have to make do with what you have. I always use my client, as I said, as the first witness, unless I have a predicate issue to worry about. I want the judge to hear everything through my client's perspective first. Then I'm going to move on to my experts, and then I'm going to move on to my lay witnesses. You want to do your evidence in the best order that you can. So you want your best evidence to come first and your weaker evidence to come last. I personally believe the judge stopped listening to you like 2 hours into the day. So if you've gotten everything in that 2 hours that was important, then you're probably pretty good. You want to make sure your witness is prepared. Your client is the best tool you have for your case, period. Even if you think that they won't testify well, they're still your best hope. So what I like to do is, and I always do this for the direct of my client, I write out every single question I'm gonna ask, every single one, from state your name forward. About a week before trial, I call the client into the office and I give them the list. And I say, here are all the questions I'm gonna ask you. And I tell them that, some things might come up during trial that might change the order, or I may have to add a question or take a question out, but in general, this is everything I'm gonna ask you. And I give them some guidelines for how to think about their answers to the questions, and I tell them to go home and practice. 2 days later, I bring them back into the office. They sit down with my paralegal, and my paralegal goes through and asks them every single question and sees how they answer. She's evaluating their testimony, so she's checking their tone, their completeness, how they're verbalizing their answer. Are they saying what I want them to say, what the evidence needs them to say? And she kind of guides them a little bit. And then we send them home again, and we say, go practice more. They come back 2 days after that, and they meet with me. By now, they've actually, if you have a decent client, and I find most clients will actually practice for you, they're in pretty good shape, and they're comfortable. They're much more relaxed than they were. They know what's coming. We're still a couple days in advance of the actual trial, so after they meet with me and they get my final assessment on what's going on, they can go home and practice even a little bit more. So by the time it's complete, they've practiced those questions so many times that I've actually had clients, after the day's over, they're like, you skipped this question. I'm like, okay, well, I can't ask you every single question on there. Like I said, trial's fluid, but they'll memorize the outline. And they'll have some comfort level, so they'll testify much better for you. It's also going to help them fully develop their answer. A lot of times the clients don't know why you're asking the question that they ask, and they give you the answer that you think you want, even though that's not really what you're looking for. So it's going to really polish their answer for the court. If you guys have never done something like that before, I really urge you to try it for like a hearing or something and see if you like it, because I found that it's very useful. I didn't used to do this, and I started doing it about, I'd say 8 months ago, and I think it's really turned around the testimony that I've been able to present. So I suggest you give it a shot. Okay, so for my last few slides today, I wanted to illustrate for you the difference between good exhibits and bad exhibits. I have a bunch of examples here, and I'm not going to spend too much time on each one, but I did want to kind of go through them a little bit to show you. In general, when you're talking about exhibits, I think people should try and use photographs. I rarely see people use photographs at trial, and it's really a shame because I think they can really effectively tell your story, especially with personal property and jewelry and things like that. When you're having value issues, pictures say 1,000 words. So I had a case once where I was arguing that the husband was dissipating marital assets. And I could have used credit card statements or bank statements. I could have used a summary to show what the husband was spending his money on and what he was doing there. I could have used a CPA. I thought that the receipts for this particular case might be a little bit more effective. And then maybe a color photo would really illustrate the point. This is an actual exhibit I used in court, and it got that same response. The picture is going to be so much more effective than just showing a bank statement. I mean, all I needed to get in was the, $1,575, the total at the bottom of the receipt. That's all I needed. But it doesn't grab your attention like the 17 rum and cokes, the 4 lap dances, and the live nude sign, does it? So you can do some really creative things with your exhibits. But if you don't plan in advance, you're not going to have the time to think up things like that. All right, so bad exhibits. The next 5 slides are going to be your bad exhibits. They're cluttered, they're unreadable. I mean, I don't even know, if you think the judge is going to read that, there's no way I can even figure out what it says. And it's blown up, 10 times its normal size for you. Long lines where you can't read from one side to the next. You can't follow the line unless you have a ruler. Same thing here. There's not that much information on it, but it really doesn't do anything. It's not exciting. This is just way too much information. Again, if the judge is reading this, he's not listening to the testimony that's going on, so you're losing his focus there. This one too, this was a tracing issue gone horribly awry. You can't even see where the arrows are going. I mean, it's just not effective. The judge isn't going to look at them. They're not persuasive. You need to remember that simply because you have a lot of information to present doesn't necessarily mean that it should all go on one page. I much prefer multiple exhibits as to trying to cram them all on one, kind of like you see here. And you need to have specific info that's telling the judge what you're trying to do. All right, so good exhibits. The people I took the good exhibits from wanted credit, so that's why their name is up there. And the people I took the bad exhibits from, I did not even tell them I was using them. So, so let's go through some of the good ones. Okay, look at that. Totally different than the 5 you just saw. It's in color. It's easy to read. I really like calendars for custody cases. I think they're really effective at showing what's going on in the case or what you want to see happen in the future. Charts are really good too. There's a lot here, but what's interesting about this chart is it's the exact same information, just in 2 different formats. So if your judge is a numbers guy, he's going to look at the top, and if your judge is kind of like a graph guy and wants to just look at the bottom, he has that option too. So that's why I put this one in here, because I kind of like the difference there. If you have a CPA testify in conjunction with something like this, the judge may not catch everything, but the numbers are there for him to go back and reference if he really needs to. Flowcharts. I don't use flowcharts a lot in family law, but I think that they can be effective tools to illustrate points. So just something for you to think about. And I put a lot of these in here in hopes that you guys would copy and steal whatever ideas you liked. Timeline charts are really good if you're trying to show before and after marriage events. They're also really good if you're trying to show how the value has changed over the course of a marriage for, like, let's say, a marital home. So timeline charts are something you can use. The title to your exhibit is important, okay? This one, not that great of an exhibit. I mean, it's not exciting, but I like the title on it, which is why I put it in here. And the title's pretty basic. It's just Summary of Husband's Income for Tax Returns for 2008 to 2012. But it tells you exactly what it is and what you need to know. So that's why I stuck it in here. Pie charts. I love pie charts. I think they can be really effective for certain types of information. This is a really perfect example of it. The number for this equitable distribution for the marital estate that we were asking that the wife should get was $1,253,000. Well, if your judge sees $1,253,000 on something that looks like this, doesn't really mean anything. But you can say, look, judge, look how small percentage she got. It's at $1 million, that's nothing. So that's why I like pie charts. This one has a lot of data, but it's neat and it's clear. And unlike the first exhibit we saw that was in the bad exhibits, this one's a lot more readable. This is another one that I really like. I try a lot of alimony cases, and I think that this effectively shows that bar graphs like this can effectively show spending habits of the spouse. So for here, this was done by quarter, and it showed the wife's spending per quarter. And when you get to that first box, what that was is the husband filing for divorce. That's what that is. So you can see that immediately after the husband filed for divorce, she met with an attorney who said, increase your living expenses, and that's exactly what she did. The interesting thing about this one is then they voluntarily dismissed the case and decided to reconcile. So box number 2 is when they reopened the case. Again, you can see the same thing, another spike in expenditures. So So this is something that's really effective to show how the wife's actions were influenced by the filing of the divorce. Another one that does kind of the same thing, but in relation to the last exhibit, it's looking at a specific quarter. Another timeline, I just wanted to throw a couple examples in there of different types of things that you can do. And like I said, please feel free to use them in your own practice and steal from them. This is a tracing one again, but this is a lot more effective than that bad tracing example that I showed you earlier. Again, something that's a little bit easier and clearer to read, despite the fact that you're trying to contain a lot of information. And I wanted to, like I said, just put a few other examples in there for you guys to kind of use and check out at your convenience. Some schedules of income, so you can kind of see some different examples there and different options for how to present them. Okay, trial binder index. This is what I was talking about earlier. So this is what I do, and this just sits at the front of my exhibit book, very plain and simple. The order I'm presenting the exhibits in, the marked and identified column, so I can easily go through and check and see if I've missed anything when I go back. To put in my final judgment, referencing X number of exhibits, you want to make sure you have that all down, and this is an easy way to do it. And then I just wanted to give you guys some other resources that you can kind of check out if you're interested. I really hope that you guys can utilize some of these ideas in your own practice, and I encourage you to prepare your evidence in advance. It's going to make you much more effective in the courtroom, and it'll really be a winning strategy for you. So thank you.